This is NDTV and you are watching NDTV Prime.
Brigade presents The Realty Debate, powered by Reliance Home Finance with Manisha Natarajan.
Is the Real Estate Regulator Act or RERA getting diluted even before it reaches anywhere close to being implemented at a state level? Well, Fight for RERA Group believes that it is and says that the Real Estate Act 2016, which aims at protecting the rights and interests of consumers and promotion of uniformity of business practices in real estate, may be left toothless by policymakers. Welcome everyone to the Realty Debate. To discuss and dissect this, we've got with us some of the top names in the industry: Niranjan Hiranandani, CMD Hiranandani Group and President Naredco West. Mr. Hiranandani, thank you so much for joining us. Good to have you back after a very long time. Also with us, we've got Abhay Upadhyay, National Convener, Fight for RERA, the tireless crusader who has been out to get justice to lakhs of buyers who've been stuck in delayed projects. Sudipta Kumar Pal, Advocate Supreme Court, who's dissected RERA point by point and of course has a case to present today. And Sameer Jasuja, founder and MD of Prop Equity, with his unique insights. Gentlemen, thank you very much for joining me. I'm going to dive straight into the discussion. Abhay, what are you really afraid of? I mean, are you too afraid without a reason, or do you have some solid reasons that you think RERA is getting diluted?
Well, thank you, Manisha, for giving me this chance. Actually, once the rules came out, before that we were very highly optimistic that all the points will be covered into. But after this rule came out, we are really now disappointed reading the rules, and we find that there are big loopholes. As you know, there is a difference between ongoing projects and the new projects. The rule should have taken care of that the needs of the ongoing projects are totally and completely different. As for example, if you can see that sanction plan, layout plan, specifications needs to be submitted to for registration. Now the rules is not mentioning that all the plans in case of existing projects needs to be submitted to the regulator. Similarly, the Act says that time period for completion needs to be informed. Now that can be futuristic. Now builder has already, in case of ongoing project, has delayed project by more than 10 years. The scheduled handover might be, say, 10 years back. So the rules must have a provision which says that in case of ongoing projects, all the delays which has happened and what was the original exact handover date should have been required to be mentioned, which is not there in the rules. Now let us come to the very important provision of the Act, which says that 70% of the sales proceeds needs to be deposited in the separate bank account. Now, why was that provision made? Because to cover the cost of construction. Now, here, in case of existing project, most of the builder have already taken 80%, 100% of the money. Now, if there is no clarification, then builder will only submit whatever future receivables he get, which will not make any sense, and project cannot be constructed by that amount. So, in my opinion, there should have been a clause which says that already money received, less cost of construction should be deposited in the separate bank account, which will at least cover the future construction cost. Now, all these safeguards are not provided in the rules, which is now giving big loopholes to the Act which has come up. And probably if these loopholes are not plugged, probably, the situation of the home buyer will remain as it is. We have been suffering for last more than a decade now, and probably this Act will not provide relief.
Okay, fair enough. I think you made very, very important points. I'll go to some of the dilutions which I'm not comfortable with, but let's delve on what you're saying. So, Sudipta Pal, come in here. The wording of the rules released by the Centre for Union Territories has left these loopholes, isn't it? Like application for registration of projects to the authority. The law makes it mandatory promoters of all ongoing projects which have not received completion certificate to register, but it doesn't talk enough in detail about what happens to the projects which have already been delayed. And this is a very valid point, and every buyer who's stuck is waiting for justice.
See, let us understand one thing, that this law is not a retrospective law. No law can be retrospective, in effect.
Okay.
But the good thing about this is that it has opened one thing, that projects which has not yet obtained the completion certificate would come within the purview. Now, once the lawmakers have said this in their wisdom, it means that projects which are delayed, that will also be considered. See, we cannot turn the clock back. If a project is already delayed, these are documents which are available. A builder, a buyer, everybody knows that a project is delayed, but it has not yet obtained the completion certificate.
So, Sudipta, then tell me, in case of a delayed project, what Abhay is worried about is it doesn't probably specify all of these things, what happens to the money that the builder has already taken, which is in some cases 90%, and you know what will happen, because he's only going to report the future date of completion of construction and not go back into the past. You're saying that it can't be applied retrospectively, and I really think that is absolutely a no-go. In a country where law start getting applied retrospectively is never going to be up for business. I mean, that's not the right climate. But how do you strike a balance between these two and make sure those who've got, does the bill have enough, or let's say have enough teeth to protect those buyers and get them justice then, as you see it today?
See, we'll have to understand this particular law brings in certain ratios. The ratio is that you cannot spend the entire money, you have to keep account of the money, you have to keep a substantial part of the money.
You're talking about future projects, and I think what Abhay is talking about...
No, I'm talking of even the past projects.
Okay, fair enough.
See, the thing is, if there is a project which is 5 years old and the completion certificate has not yet been obtained, now he has to get himself registered. The moment he gets registered, today the biggest problem with all projects are that we don't have a referral point. The builder is not given anything to the government to say that this is my project, this is my land, I'm going to complete this project in 5 years. Here he has to declare that my completion date was 2013. Today in 2016, I have not yet completed. Now, rest of the ratio, how much money did you spend? There is a very good concept that has brought in as to how much completion has been done. Now he has to quantify how much money he has spent out of the whole money that he collected. All these things are there in place. The amount of money he has collected from each purchaser is all on account. So he has to actually come back to the drawing board.
So you're saying that there are enough provisions in the Act to hold builders of delayed projects accountable. Let me bring in Mr. Hiranandani. I'm sure every builder has seen it in deep detail, and him being, of course, a veteran in the industry, heading Naredco as well. Mr. Hiranandani, are these fears valid that, you know, your biggest stress in the market today, less accepted, is because of the trust crisis, and that trust will get restored only when you have rules protecting buyers? So tell me, is there enough in the provisions to protect those buyers who are stuck in delayed projects?
To be honest with you, I think I agree with the problems of the consumer because of the retrospective effect not being there in the law. But you have to understand that the law is already effective in terms of consumer courts which act today in respect of the older cases. What is happening is that the law is prospective very clearly, but it's also for the ongoing projects. But how the action has to be taken in terms of money which is already withdrawn by the builders, it's not possible for them to bring it back again into the projects or to make a deposit of it. So hence it cannot be made retrospective in that respect. So it's not, so there are two parts to it. First, you can go to the consumer courts because that will be available to them. And second, they are also saying that the ongoing projects will be under RERA. So how they will be brought in effective and which are the terms and conditions are going to be brought in, I guess we'll have to wait for the rules to see and specify how this action is going to be taken place. For instance, if the project is already delayed, then we will have to find out what the regulator is going to say, because it's not retrospective, and hence according to me the consumer courts which have already got the rights at this point of time will continue to act in respect of defaults which have already taken place, and it won't be the RERA courts. However, since they have said that the regulator will take charge of all the ongoing projects also, we'll have to see how these regulations come by. But I agree that it is not retrospective in action. So during this intervening period, there's going to be a problem of those who have already bought, but the delay is taking place. It's true and correct, the interpretation which has been talked about, and that is a position as far as RERA is concerned as it stands today. But we'll have to see the regulations. I mean, the detailed rules are still to come out of the various states. We expect that Maharashtra will bring out the rules within 2 months. That's what our housing minister has said and announced on the floor of the assembly yesterday or day before yesterday. And hence, we expect that once the regulations come, the rules come into play, we will come to know as to what is going to happen about these intermediate cases.
Okay, so before I go back with my second line of questions, here's what's happened. Now that you've spoken about it, Mr. Hiranandani, you know, Maharashtra government has definitely been the most proactive. They have actually said in the monsoon session, the housing minister said that the rules for the housing regulator will be finalized in 2 months. We've always also seen it on Twitter. The officials involved in it have said that the work has been very proactive. In fact, the rules are ready and they have been reviewed by the minister. Haryana now, what's happening? Now, remember that the maximum distress is in actually these markets. One is Mumbai in Maharashtra and NCR, which is probably way ahead even of Maharashtra in terms of delayed projects. Haryana still grappling with administrative issues. A BJP government there, a BJP government at the center. Yet the Haryana government is yet to begin on the draft rules. The government does not even have, Haryana government does not even have a housing secretary. So you can imagine how far this is. Karnataka, again, Bangalore is a big market for housing. The state hasn't started the work on drafting the rules either. The Karnataka government, whether it has appointed the principal secretary of the Housing and Urban Development as a regulatory authority, isn't also clear. So the Real Estate Act of 2016 leaves the task of drafting the rules to the states, since land is the major component of a state list. Let me come back to you, Abhay. I mean, looking at, so one is the dilution, and I think Mr. Hiranandani has already validated your fears and said, look, it's going to be up for introspection and there's only that much that you can do to protect customers who are stuck in very delayed projects. Maybe they'll have no other fallback but consumer court. Tell me, in terms of forming the rules per se, I mean, do you really think that 1 year deadline is going to be met, Abhay?
Well, as far as states are concerned, I have my doubts. So that is why we want to be this, our movement Fight for RERA is working on this, and we are trying to activate our state level units so that we can pressurize state government. But Manisha, I'd like to just touch upon the point raised by Mr. Hiranandani, that consumer courts we have to follow upon. Now the important point is that consumer courts have, failed in last 10 years giving proper appropriate justice to the home buyers. And had the justice been given to home buyers, there was no need for this law. And our parliamentarians, lawmakers are aware of this fact, and that is the reason why they have included existing project. And if once they have included existing project, that means they have accepted the fact that at present the legal system which is there, that has not delivered justice. So if you ask us again to go back to consumer court, then probably that means that we will have to continue, our situation will remain as it is the way we are now. So what is the point of including existing project in this act?
Okay, I think Mr. Hiranandani has a point to make on that. Let's bring him in, because Mr. Hiranandani, you're shaking your head. I think what you said is that it's still open to interpretation, isn't it? I mean, it looks like it can't be retrospective, but go ahead, sir. What's the point that you'd like to make?
What has happened is, in the case of ongoing projects, there are three possibilities. One is that if there are no flats sold in the existing projects. Second, if part of the building is sold in the existing projects. And third, if all the flats of the existing projects have been sold but occupation certificate has not been received. What the government wanted to include, earlier there was a issue that we had asked for none of the ongoing projects to be included, because there is a problem of this transition phase where it would be difficult to carry out interpretation as to how the law will be enforced for existing customers, present customers who are now buying, and future customers. So the decision which was taken was that they would include all the projects, including the ongoing project, because there will be large number of newer customers in the ongoing projects which would also be there, and future customers in existing projects. And that is the reason why even those buildings where no occupation certificates have been taken, though some of the apartments had been sold or most of the apartments had been sold. Otherwise, the government was in a quandary as to whether to make existing projects under RERA or not. However, it was decided in the wisdom, and correctly so, that even ongoing projects would be taken under RERA, but in fact it would be in a way prospective, because the RERA could not impound the monies which have already been taken away by the developers, nor could those transactions really be impounded upon. However, when the rules are framed, the issues which will come before the regulator will be obviously seen in a total perspective, and the regulator probably will have the judicious capability of handling both the cases in respect of old and new. But they would not be able to impound the monies which have already been deposited with the developer and already used up. It's no possibility to do that. However, these detailed rules will indicate as to what direction are being given by the state governments in respect of to what extent the existing customers, as has been mentioned by Mr. Upadhyay ji, would be affected positively by RERA, or would they have to really go back to the consumer courts. My view is RERA will be taking into position, but they would not be able to implement the full position as far as that is concerned. But it is a matter of interpretation of the rules which are not yet in front of us to understand what is the full impact or in respect of the existing customers.
All right, fair enough. Now, so we are saying that, okay, how does RERA really bring back the money which has already been siphoned off or diverted to other places? I think that's a fair point. I don't think the regulator will be able to do anything. What the regulator can do is, if it sees mismatch of or misuse of funds, it could have jailed or at least done some punitive action or taken punitive action against those developers, which consumer courts for as of now are unable to take. And here I see there's another dilution, isn't it? Where it says developers can now avoid jail by paying 10% of estimated project cost for non-registration of the project or violation of the order of the Real Estate Appellate Tribunal. So I'm left wondering, I know this is for ongoing projects and to violate anything that the appellate says, but Sudipta, come in here, how do I interpret it? I mean, at least RERA should have the powers to immediately say that, okay, this is your new timeline. If you're not, give me a new fresh timeline. Right now, any delayed project, you're not able to get a developer to give you a timeline of completing the project. And B, if you don't follow this timeline, we throw you into jail. Now, does RERA really cover that?
It does.
It does? Okay. So RERA can throw these developers, and frankly, I think it's about 5-6 developers who have delayed the maximum number of flats.
Yeah, it is just the compounding part of it. If he can't pay, see, let's understand, 10% of the total project value is a huge, enormous amount. If a promoter is actually found to be guilty, he has to pay 10% of the total project cost, which is could be hundreds of crores. Now, if he can't pay that, he has to go to jail. See, the thing is, we have to understand the law, the purpose of this particular law is, which Mr. Upadhyay is trying to find out is, see, the rules works out as to what is the quantum of compensation in case of delay. There is not going to be an ambiguity in terms of how much money a person is going to get. It very clearly says that it's going to be more than the state bank's interest, 2% above it. Now, today, most of these old allottees are grappling with the fact that how much is going to be my compensation, actually, am I going to be compensated? This rule will come in, and the regulator will very clearly tell a person that this is the amount of compensation you are going to be paid month-wise. And see, the promoter would be under tremendous pressure to complete the project, because if he has to pay such kind of a penalty month on month, the best thing for him is to go and complete the project. We have seen this in various high courts and consumer courts, that the courts always put in these kind of pressure so that the promoter first completes the project. The purpose is served if the project is completed.
Is it happening? Sudipta, I mean, are courts putting pressure, and are these projects getting completed? Where are they getting completed?
Now see, this is where this law has come in. Mr. Upadhyay said, I would not like to use any word about how much a court has been able to do. Court is there to interpret a law and make use of the law. Today, if the law is giving the court a right to penalize a person, to put some kind of a fine or put him behind bar, then they can do that. If the law does not permit the court to do that, courts can't do of its own.
Okay, fair enough. Sameer Jasuja, come in here. You have not only been an intricate part of this industry, you yourself have fought many cases where real estate has got stuck with builders. How much do you think RERA will resolve it? Because not everyone can go to high court. Consumer courts, yes, there have been some victories, but guess what? Consumer court, verdict can be challenged in Supreme Court, and that means even more delays. So really, what do you feel about this?
Well, my view is that we need a regulator like RERA. The only thing is that it has to be given enough teeth to be able to act upon the laws and be strict about it. If that doesn't happen, if it's a toothless tiger, then we are back to an equivalent situation of the consumer court, which is really, and I have personally experienced it. It's really, justice is really delayed, and I would say it's so delayed that it's kind of denied only. And when you're talking about bank interest in form of penalty, developers are borrowing at 18 and 24%. It is actually in their interest to delay as much as they can, and so that the interest, even if they have to pay as form of penalty, would be 9 to 10%, which will be much lower than what the amount they're borrowing in from the market. So it's in their interest. Till RERA does not actually go and implement these laws very strictly, we'll be always in a difficult spot. I'll just give you a small example. There's a little bit of fraud that happened with the National Stock Exchange with one of the brokers over here. Within 24 hours after filing a complaint with NSE, the regulator started contacting us. Imagine this situation. The regulator is contacting you, asking you, are you going to be settling in with the broker? Within 15 days, we'll give you a judgment whether the broker is on the wrong side or you are on the wrong side. I'm talking about NSE. NSE is also acting as a regulator, and you can go and complain to SEBI. The financial markets in this country are superlative when it comes to these laws, and really speaking, the developers should wake up and see that if they can comply with the laws and make sure that RERA can be effective, they are going to benefit actually the maximum, because the trust deficit will go away and residential real estate will be back in the reckoning. It is only because of delays and risk that is there with new projects now. Sales have plummeted to less than 10% of what they used to be 5 years ago.
Final question, Mr. Hiranandani, there are some developers who have actually gone completely bankrupt, some of the largest defaulters in NCR and some of them in Mumbai market as well. You have the likes of Orbit who just don't have the money, and even, their properties have been forfeited by the lenders. Now what happens even if, RERA says that the regulator says, tribunal says that you have to pay so and so interest? When they don't have the money, then is jail term the only option left? And then does it become like terribly draconian? Or do you think they deserve it?
The answer is yes. The whole purpose of the act is to make it draconian, to act as a denial of rights to the developers in terms of it. If they are not able to fulfill the terms and conditions, yes, it is considered draconian, and most of the developers do believe so, especially in cases where the approvals have been denied by the government, or they are forced into certain things which have happened which is beyond their control. For example, forest areas were declared in the areas around Mumbai. The National Green Tribunal has given certain orders and other things which have happened, some of which are not genuinely the builders were not aware about the restrictions which were there. So the builders, on the other hand, do feel that there is sometimes a denial of justice in these cases. However, the major problem is twofold. I think from a consumer's perspective, the law is very clear. It is meant to be draconian against the developers, and that is the intent of the law. However, certain things are missing where it is beyond the control of the developer, and there are genuine problems which have taken place as has happened in the past in certain cases. I don't know. The third part of it is absolutely untold. What the law tends to intend to do is that for the prospective projects to secure the consumers completely. That is the intent why 70% of the money is sought to be impounded. Which means what the lawmaker has decided, what the governments of time have decided, that in future, such issues which have taken place in the past will not happen in the future, because there will be sufficient land. There will be sufficient money in the bank for us to complete the projects if the developer fails. Also, the fact that there is the regulator's right to take away the property. Now, how this will be dealt with by the borrowers or the lenders of the banks is yet to be seen, because there will be two contrary provisions. One, a security taken by the banks, and the second for the lending of the money, and the second, the right of the regulator to take over the property. I think the courts will hold that the rights of the consumer will stand higher than the mortgagors. So I think the rights in future is sought to be projected. What the problem is, and I see that completely, is that what happens in the interregnum period, which is the time where the people have already invested, but they are not able to do it. I think this is a grey area which has not been thought through completely by the regulator, because what was intention is that as we talk about housing for all and more houses are provided in the future buyers who are entering into prospective agreements are 100% protected by the regulator, as well as the money being impounded will take total care of it, with the rights of forfeiture of the property if the developer does not complete the project. So the developer in future, the consumer in future is 100% protected by this law and the provisions of this law. However, as Mr. Upadhyay ji puts up fears, and as you have also repeated, there is a grey area for the intermediate positions where the developer is today bankrupt, does not have it, has used the money for other projects, or have made losses in the projects because of wrong investments into lands and other properties, which has happened to several developers, especially in North India.
In North India. Okay.